speaker sucks because this one broke. I mean, yeah, it's working.
All right, we're going to get started now on the Thurston County District Court
They're both working.
Harassment Protection Order calendar
Okay,
for
it's just
December
going.
7th of 2020. Let's find out who's here first of all. Calling Hadley Barton. Hadley Barton? No. Jordan Lozano? Jordan Lozano? No. Gretchen Messelt? I don't see Gretchen Messelt. All right. Yes, log in, let me know. And James McCleary. All right, no James McCleary. All right, Joseph and Jocelyn Kabazinski. See you there, Ms. Kabazinski. Okay, and then Shannon Pardee. See you,
Here.
Fox. All right, good morning.
Good morning.
Okay, and I do think we have one more person logging on, and I think that's Miss Messelt. Just bear with me a minute here. I have one person who was logged into the wrong courtroom, and I want to get her oriented. Did you say she was having trouble logging in, or had just logged in the wrong courtroom? Okay. Okay. So she just went to the wrong courtroom. Not a problem. All right, and there I see Mr. Kabazinski. All right. Yeah. I want to take her matter as soon as I can because I think that's going to be quick. There she is.
Come on, Missy Wiz.
Her audio hooked up.
Come on, Missy.
Okay, looks like she's in. All right, Gretchen Messelt. All right, Miss Messelt, are you with us? And Miss Messelt, are you here?
Yeah, I'm here. I thought we're here.
All right, Miss Messelt, I'm going to call your case first, 20-263, and I already called for James McCleary, and he's not here, and I reviewed the file, and it looks like he's still hasn't been served yet. So, Ms. Messelt, have you had any progress trying to get Mr. McCleary served since last time?
I have talked with the police. They have told me they've tried a few times. They told me that they said only to call if there was an incident, and not to call the emergency number. Only the usual number, and if I do that at 3 o'clock in the morning, which is usually when he's causing trouble, they won't answer the message for like the next day. So anything I would say would just be irrelevant. I don't know where he is at 8 o'clock in the morning. I just know where he is at 3.
Okay, so you haven't been able to serve him yet. My question will be...
They won't let me serve him. They won't give me the paperwork.
No, you can't do that. You can't do that yourself.
Themselves.
Okay,
So,
Ms. Messelt, listen to me for a minute, okay? My question is, do you want another opportunity to get Mr. McCleary served in this case?
yes, I actually would.
Okay. All right, we're going to do that then. I'll give you another opportunity. This will be, I think, the second, and we'll get you rescheduled for the next available calendar, and I'm going to have the clerk tell me when that is. All right, the next calendar, Ms. Messelt, will be on December 21st, and I'll extend your temporary order one more time until that date. Okay, so I'm signing the extension of your order for another 2 weeks till December 21st. Give you another opportunity to get Mr. McCleary served, and we'll see you back here on December 21st, okay?
All right.
Same time, same courtroom?
It'll be, it'll be December 21st in the same courtroom, yes.
Okay. So courtroom
See you
3.
then. Mhm, that's
Courtroom
right.
3.
That's right.
That's where you are. Courtroom 3.
That's where the hearing will be, yes.
Thank you. All right.
You can log off whenever you like.
Okay. Thank you, sir.
Yep, you're welcome. Okay, and now I'm going to go to Kabazinski's versus Pardee, 20-269. All right, and Ms. Pardee, I see you're here with somebody else.
Yeah, I'm Bill Pardee. I'm her husband, but I'm also representing her. I'm an attorney in the state of Washington. Bar number 31644.
Could you say that one more time? It broke up.
William Pardee, Pardee. I'm going to be appearing for her as counsel today. I'm also her spouse. My bar number again is 31644.
Okay, thank you.
You're welcome.
Okay, are you going to be ready to proceed with this hearing today?
It's not our hearing, but the Kabazinski's hearing. Yeah, we're
I
ready.
see that.
Ready to see.
Okay, and I see Kabazinski's are here. It looks like, yep, I've got you both here. Okay, and are you ready to proceed with your case?
Yes, Your Honor, I am. But first, I would like to object that we did not receive any kind of notice of representation from Mr. Pardee on behalf of Ms. Pardee. So this is notice to us that he's appearing in court this morning. Can you hear me?
I can. Yep.
I apologize. I seem to be having some connection issues because everyone appears to be frozen on our computer. So I'm just making sure. Can you hear me okay, sir?
Sure can. Yeah, can hear you just
Okay,
fine.
thank you. So despite our objection of no notice of representation from Mr. Pardee, we would like to continue forward with this because it's important. We want this to stop as soon as possible.
Yeah, it happens a lot.
Yeah. So
I just wanted to let
the
you
purpose
know
of
that
this, Your Honor, just yes, sir.
People are frequently represented by counsel in cases like this, and counsel comes in relatively late because the timelines for these hearings, once these cases are filed, are very short. So there isn't always a lot of
Yes,
time for people to give notice. And I always ask when attorneys appear, because I always ask them if they're ready or if they need a continuance, because they don't frequently they have not had the case for any more than a couple of days. So frequently they need more time to get ready for a hearing. So that was the reason I asked. I don't think there's any sort of prejudice because an attorney appears, though. All right.
Oh no,
so
sir. We're prepared to move forward.
Okay. Well, then what I will do is swear in the parties, and then I'll hear from the Kabazinskis first, and I'll hear from Ms. Pardee next. Typically, if there are witnesses, there may be a need to question them. The Kabazinskis had witnesses at the last hearing. I don't know that there are any this time. I don't see any logged on. Okay, good. And Ms. Pardee, I don't know if you have any additional witnesses either. I don't see any logged on.
No, she does not.
Okay, very good. All right. Okay, let me get this started. So can I have each of you raise your right hand, please? And do you each swear that the testimony that you give in this case will be the truth?
Yes.
I do.
Okay, thank you. All right, and again, since the Kabazinskis are the petitioners here, you'll get to go first, and you can choose between yourselves who gets to start.
I will speak for us. I think my husband, sir, might be having a few connection issues. He's on, but I'll speak on behalf of us, but he'll be available if there's any questions. This is pretty, I don't have a whole lot to present, Your Honor. You oversaw the last case and everything that happened with regards to the denial of the protection order. This information that comes following that hearing, and a few things that happened during that hearing that were alarming in nature. Other than one time that we've actually had contact with Miss Pardee in August of this year, we've actually had no contact with her, don't see her, we don't even live in a similar part of the neighborhood. However, she has chosen to interject herself into the issues that we've had with Ms. Holmquist on a regular basis, with no credible information, no information that shows that there's any relevance to any accusations, or furthermore. I would also like to add that while we had a civil anti-harassment order with Ms. Holmquist that
Stop
we
fucking
were
saying
in
my
court
name,
with her
bitch.
last
My
week for
fucking
an
name out
arraignment,
your
and
mouth,
due to
bitch.
the increasing amount of behavior, including the behavior that we've experienced from Ms. Pardee following the denial of Julie Holmquist's request for an order, they have now issued a 2-year protection order against Ms. Holmquist, protecting us and our family, and from third-party harassment as well, because the behavior has been escalating, and now it's starting to fraction out, and people that have been associated with Ms. Holmquist, as you can see, has been part of this. The most alarming part about this, Your Honor, is that she's made direct and intentional alarming accusations for no purpose, with no finding and no basis, to my husband's employer, to the major, and for no other reason, with no support, citing that Joe is building bombs in our shed and that we are harassing and intimidating her. All of the same accusations that Ms. Holmquist made to Major Plemons that were unfounded. And even in the evidence that Ms. Pardee has presented on her behalf, she admits that she called. And it says within that statement that at this time that there's no further legal action to be taken. So the fact that she, as an extension of Ms. Holmquist, would intentionally make contact for no other reason than to alarm and create discontent at my husband's employer is enough, we believe, for we want this to stop, to issue the anti-harassment order. I did make contact with my own employer as well, to out of concern that I was trying to head it off long before it happened, to make sure that I don't find myself in the same position. In the last hearing, Your Honor, it was evident she's done a lot of background knowledge on us, knowing about our business and things that, yes, I understand it's public information, but the reason that she would have any reason of any kind to have to research this information on us is alarming. And it makes us, it makes us really uncomfortable, and we shouldn't have to be notifying our employers of false accusations and allegations as an extension of what we've experienced from Ms. Holmquist. I presented to you the police report in which she was involved in August. I also presented you with two sworn statements from Lieutenant Wilkins, who's Joe's direct upline supervisor under Major Plemons, and from Specialist Mason Clark, who took the original phone call from Ms. Holmquist, who provided that number to Ms. Holmquist. And as far as we're aware, until reading this memo, we didn't have any kind of knowledge that this was a public phone number. So it's alarming that would come about. So my husband would also like to speak, Your Honor. That's all I have to present. I believe we have enough. Sorry, my fire alarm's going off. I have enough that we should be issued this anti-harassment order, because this was completely, there's no basis for any of these accusations. There's no basis of any intimidation. She's presented nothing that we've done any harassment, brandished any weapons of any kind, nor that we're making bombs or Joe's making bombs in the shed. So this was an intentional to disrupt his employment and try to create some sort of a circumstance to get him in trouble with unfounded accusations, Your Honor.
All right, Mr. Kapuzinski, are you able to turn on your audio?
Yes, Your Honor.
Okay, and would you like to also add to the statement that's been made?
Yes, I would, Your Honor.
All right, go ahead, sir.
Well, thank you for having us here today, Your Honor. I'd like to start with, first of all, saying I have never had but one interaction. I've taken that back, 2 interactions with Miss Party throughout my entire almost 3 years of living in our neighborhood, and those interactions weren't more than 3 words spoken. The only interaction that we'd had with her in the year 2020 was an incident that involved a gentleman by the name of Tyler Rosso, where he had came to our home and made threatening remarks to my wife, my family, and our animals. And at that point, Mrs. Party and Mrs. Holmquist ran across the street and persuaded Mr. Rosso to leave the residence, and he did. And from that point, we parted ways. The only other interaction I've ever had with Mrs. Party was it was a year and a half ago. A friend and I were launching a boat at our HOA. She pulled up and started asking us random questions about signing her petition in an active lawsuit against our homeowners association, which I wanted nothing to do with. I didn't know her from Adam, and I declined her offer and went our separate ways. It was about 2 sentence transfers. Outside of that, Your Honor, I don't know what Mrs. Party looks like. When she was a witness for Ms. Holmquist in our sworn testimony a couple of weeks ago, I didn't recognize her on the computer. I don't know where she lives. I don't know what kind of automobile she drives. I don't know her husband. I don't know anything about her and wouldn't want to know anything about her. She's not got anything to do with me, and she's not my business. The reason I preference that is one of 2 things has happened. Either she has actively utilized Mrs. Holmquist's information about myself to my employer to contact my employer with very slanderous accusations and defamating my character, or she went to great lengths by researching on the internet who my battalion commander was and what our duty phone was. Either one of those 2 scenarios is very heinous in nature, and the fact that she would, the very day after the last court hearing that we had with yourself and Miss Holmquist, she took it upon herself to contact my battalion commander and start saying to him that I've been threatening her, that I was making her feel uncomfortable, and that I'm making bombs in my shed. And her only claims to evidence that I'm making bombs in my shed was that she had an uncle that at some point was an explosives expert who had a shed that was very close in dimensions to mine, and he was doing the same thing. Your Honor, the truth is that's illegal. I don't take part in any illegal activities. I have no interest in making homemade explosives in my property, my residence, or anywhere for that matter. What I do in my profession is not make homemade explosives. I'm not trained in making homemade explosives. I don't have the equipment to do that. And furthermore, I'd preference that in my shed, if you were to look in it right this moment, there's 2 Fender Stratocasters, a jazz bass, and a set of drums. I use that shed for playing music. And furthermore, I have a close friend of mine and Jocelyn's that is a Thurston County deputy who plays the drums with me in our shed on a regular basis playing music. So we have Thurston County deputies that are in our shed quite often for music playing purposes. We have no heinous things that are going on our property. And the fact that I've never truly met or formally introduced myself to Miss Party amongst anything else is it completely alarms me to a degree that I can't express, that she would take it upon herself to call my employer, which I plan on doing a full-lengthy career in the United States military, and essentially attempt to completely derail my military career and have UCMJ action taken on me for something that she has absolutely no substantial evidence to meet any burden of proof on whatsoever. Since then, I've had multiple counselings upon the phone call with Major Clemens. I've been made aware of that if any of these things were true, the absolute ramifications of UCMJ actions, which the truth of the matter is, Your Honor, I should have never had to have these conversations with my leadership whatsoever. I've never had a disciplinary action in my entire military career. I've never had as much as a negative counseling about anything. And the fact that she would interject herself into this situation to try to make me look bad to my employers, I don't think you can do much of a nastier thing to a human being as far as harassment is concerned. And our biggest concern is that we obtain this order so that any and all of this behavior would cease instantaneously and immediately. Thank you, Your Honor.
All right, thank you, sir. All right.
Oh,
let me
wow.
turn this over to the parties. Not entirely sure how you want to handle it. If you want to have Mrs. Pardee testify, or if you have any other issues to raise.
I'd like to talk about the legalities of petition. I'd like to talk about the legalities of the petition, but also I'll first go to Shannon Pardee for some testimony, brief testimony.
Sure.
In particular, as to the call to the base, JBLM, I think that's the most important issue I've heard from the petitioner. But
Sure.
Go ahead, Pardee, and talk about that.
All right. Mrs. Pardee, go ahead and tell me your part of it then.
Well, Julie has had this issue with the Kalbazinskis for a while. I only called the base when it became concerning for me. I've heard fireworks, overly large fireworks, coming from just around that general area. I have a family member that's a major in the military, in the EOD. So if I had needed to get a hold of somebody in that division, I would have known how, but I don't use my family member. I went the route, which was called Google, and I made my concerns, because I am concerned that Mr. Kalbazinski is enhancing fireworks and making those M80 types to blow off and scare the ducks and to harass and to, in general, be a nuisance himself. And he has the knowledge to do that. That's why I called his commanding officer, because I think he's using his talents that he's been given by the military and he's misusing them. I didn't do that to be malicious or vindictive or anything else. It's not in my nature. I understand how hard Mr. Kalbazinski had to have worked to get into EOD. I'm very familiar with how EOD works. And I counseled with my family member at great length before I made that phone call to Mr. Kalbazinski's major, because I did not want to make a phone call that I didn't think was fair or right. So you may disagree with me, but I disagree, and I think that Mr. Kalbazinski is enhancing fireworks to go down and to blow up down at the lake.
Miss Pardee, could you also follow up on, you also called because you thought he was driving by your house, is that correct?
Yes, I saw this truck more than 5 times go past my house that day, black truck similar to his, and then again on another day. And so I thought, no, I'm not going to tolerate this. And yeah, they do have sheriff connection. So it's not just calling the sheriffs for me, because then they're not going to do anything. So the only step that I figured to keep myself safe was to call Mr. Kalbazinski's supervisor, because Mr. Kalbazinski, to me, is doing illegal things. Making it so simple and that's about the feathers out there. He can say now it has the poison and everything else, but that's easy to hide.
How did you obtain the number? You just mentioned it
I got the number off of Google, and then I got a hold of a Sergeant Shoes, something or other, and I explained to him my concerns and how serious that I thought that they were. And then I told him I wanted to talk to his major, and then Major Clemens is the one who had him give me his personal cell phone. Mr. Clemens gave me himself his personal cell phone number.
Okay.
Let me kind of talk. Let me talk a little bit about.
You had some concerns about the petition?
I'm sorry?
You said you had some concerns about the petition?
Yeah, I'm just speaking as a lawyer, not as a witness. But I looked at the evidence, perused it over the weekend here. Petitioners provided both a July 12th and July 13th incident involving Miss Holmquist. I think they're trying to link my wife to Miss Holmquist. They are friends, but I don't think they're the same person. They're not in a conspiracy to commit harassment or stalking here. The incident did not involve the respondent. I looked through the Thurston County Sheriff's Office incident report and a supplemental report. They do not involve my wife. There's also attached a Thurston County Sheriff's Office offense report from July 12th regarding Mr. Tyler Glasso, which the petitioners mentioned earlier. Again, this did not involve the respondent. This is being provided as evidence of my wife's harassment and stalking. There's also a August 27th, 20 sworn statement of Mason Clark, again talking about Julie Holmquist, not my wife, requesting an address for service of process. This too did not involve the respondent. I think they're trying to link and say that my wife is the same person as Julie Holmquist. That's kind of troubling. And when you're trying to seek an order for harassment and stalking, there is the 11/24/20 phone call that my wife made. There is a sworn statement of Thomas Earl Wilkins of BBLM talking about his conversation with Miss Shannon Purdy's, my wife's, the respondent's conversation with Major Clemens, and then Mr. Wilkins, who's the superior of Mr. Kavinsky, talking about that conversation. And I think my wife had relayed her concerns. That's why she called. It wasn't on the behest of Julie Holmquist. The petitioners also provide, they did not mention it, it's interesting, social media posts of the respondent on 11/23/20, talking generally about, without naming, it doesn't name any parties, it doesn't name any people, it doesn't identify any children, basically about children being coached as witnesses. I don't believe these amount to cyber stalking or trolling. It wasn't on their site, it was on our own site. I believe it is simply an exercise of constitutionally protected free speech. My wife makes a lot of posts, but I don't think this was directed towards any particular person. The petitioners state in their petition that they are very concerned that the respondent will obtain an order. And so this almost sounds like they're doing this as like a tactical move, because they see Miss Parvia seeking her own order. Possibly she hasn't, and she doesn't have any intention to, but they're kind of doing this to kind of get ahead of that and filing their own petition. The petitioners state that also in their petition, going back to the petition because they did not mention this either, that the respondent, they kind of touched on this, I think Ms. Kavinsky touched on this, the respondent mocked them and recorded them during Julie Holmquist's recent hearing in which my wife appeared as a witness and filed a sworn statement. But I think it's worth noting that in the petition, they seem irritated that respondent testified on behalf of Ms. Holmquist. Now, Ms. Holmquist was not successful, but they do say that because my wife, Shannon Purdy, filed a statement, a sworn statement, she, quote, inserted herself into the situation by providing a sworn statement to the courts. That's not illegal to file a statement on behalf of somebody that's asked you to be a witness. That's basically all my wife did. I don't think that amounts to harassment or stalking. Now, let me get to two other brief points here about the burden of proof here is preponderance of the evidence, as you know, Your Honor, for both harassment and stalking. I am concerned that the stalking box was checked to get a free filing. I know in Rockland County it worked as when you file stalking, when you check stalking, you get a free filing. That to me is very troubling. The stalking is a very high burden. I think that's abusive process when you just check the box that gives you the least cost to your pocket. I filed action, but I usually pay the court filing fee. My understanding is that when you file stalking, you check stalking, you don't have to pay a filing fee. Bottom line is petitioners have not shown by a preponderance of the evidence per RCW 10-14080 sub 3 that the above fact amount to unlawful harassment. Let me talk to why. The facts do not amount to unlawful harassment as defined in 10-14020 sub 2 because there is no knowing and willful course of conduct as defined in subsection 1, since not continuity of purpose, and there is constitutionally protected free speech here, i.e. social media posts. And no reasonable person would suffer substantial emotional distress. And I don't believe the petitioners did. Also, no reasonable parent would fear for the well-being of their children based upon respondents' single social media post. And I don't think they've asserted that today. So that is not, that's the basis for unlawful harassment. I don't think it's there. As to the stalking, the petitioners have not shown by the preponderance of the evidence that they are victims of stalking by the respondent as required by RCW 7.92.100(1A). The petitioners do not allege stalking conduct and do not list specific reasons they have made them fearful that the respondent intends to injure them or their property. I have not heard any indication that there's any sense here that Ms. Party is going to injure them or their property as required by 792.030 sub 1. Most importantly, the allegations against respondent, even if true, do not amount to stalking conduct under 79202 of sub 4, and do not amount to repeated or continuing contacts, monitoring, tracking, observation, or following that would cause a reasonable person to feel intimidated, frightened, or threatened, or that which any stalker reasonably should know would threaten, frighten, or intimidate the petitioners.
At this point, you should
Bottom
know
line is, I
what
don't.
he's done to me, this judge.
Your Honor, to consider
What these
both burdens,
people
I
are
don't,
like, you
in
know what I
both
mean? At this
statutory
point, like this,
criteria, I don't
insane.
think either have been met. We do live in the same neighborhood, and Miss Party has other friends that are down that live near the Kapuzinskis. I think it would be quite a burden on her to stay, to have a no contact order in place where she can't even go down the street. My understanding, from being told by my wife, is Julie Holmquist has told her, I don't know if this is true, that the Kapuzinskis have called repeated times. They do have a no contact order in place against Julie Holmquist. She lives much closer to the petitioners than my wife does, and I do. They've called multiple times for violations to the local law enforcement of that order. I think the slippery slope here is that if you grant this order, anytime somebody aligns or is an ally of somebody they don't like, they'll just file no contact order and say, and if she drives by that house to go to her friend's house, then she'll be cited and law enforcement will be involved. That's not fair. I don't think the burdens have been met here. I'll leave it at that. Thank you, Your Honor.
All right, thank you.
Your Honor,
Okay,
can I address a few of those, please?
I'm going to give you an opportunity to make legal arguments, not factual ones. I've heard
Sure.
the facts of this case, and they're in the record. Okay, that
Okay.
constitutes the petition and your testimony and Mr. Kapuzinski's testimony. But if you have legal arguments, like Mr. Pardee did, I'm willing to hear those.
Well, do we have the opportunity to cross-examine Ms. Pardee on
No.
questions that?
No,
Okay.
no, this is an equitable proceeding, not a legal proceeding. I don't know
Sure.
if that means anything to you, but
Yes, sir, it
generally
does. I
speaking,
understand.
Well, cross-examination can be an important part of certain types of cases. Obviously, I mean, it's clearly an important part of criminal cases.
So I do have a couple of legal
Yeah.
presentations that I would like to
And
address.
Mr. Kapuzinski's raising his hand too. I don't know if he can hear us. Okay. Mr.
Yes, sir, Your
Kapuzinski.
Honor. The one thing I wanted to ask as well was there were some very disputable things that were brought up by Ms. Pardee and Mr. Pardee's testimony. And I was wondering if there would at least be an opportunity for us to be able to resuscitate our character based on those.
Yeah, I'm not going to go back and forth because there's an unlimited amount of that could happen. Believe me, I'm fully listening to both sides. I know you don't agree with everything that she said. She doesn't agree with everything you said. It's not necessary to go back and forth with point-by-point
Yes, sir.
rebuttals. That's not important. What is
Yes, sir.
important is that you have your chance to fully tell your side of the story, and that she has the same opportunity. And in this case, Mr. Pardee has raised some legal issues that I think are important that should be responded to. It's perfectly appropriate to give a different or contrary legal analysis. And to the extent Mrs. Kapuzinski is going to do that, I'm going to let her do that.
Yeah.
Yes, sir. Thank you, Your Honor.
So a couple of things to address legality-wise, Your Honor, with regards to the concerns raised about the stalking box that was checked. We did pay for our filing. There was no intention of checking that in order to have a free filing. We did pay filing. In fact, we even paid the sheriff to have her legally served so that there was no questions raised about service or return of service or otherwise. I want to talk a little bit about the burden of proof. So in the anti-harassment order, with regards to harassment versus stalking, the burden of proof for harassment says that it has to be an action that would be of alarming in nature to a person or parties that would be involved. The burden of proof here has been met, Your Honor, and it's important to recognize the fact that the call that was made literally one day following the denial of Ms. Holmquist, whether the link is there or not, was intentional in a manner to raise concerns at his work, to be alarming in nature with absolutely no evidence to present. It was something that was meant to intentionally try to get him in trouble at his work, create some sort of open investigation, cast shade on his character. And that in itself is alarming enough to meet that burden of proof, preponderance of evidence. It's just that, the reasonable person would believe that if that preponderance of evidence is, if that action was taken, that they as well would feel that there would be some sort of alarming nature, that there would be some sort of something that would in fact create some concern or otherwise. That's well been met. As far as the stalking, let's talk a little bit about the burden of proof. It's also a preponderance of evidence, Your Honor. Since there has been involvement, and I know Mr. Pardee raised there the link between Ms. Holmquist and Ms. Pardee, and the concern that is happening here, and why we checked this particular box, is because we have had this ongoing and legal battle. The preponderance of evidence here is showing that this is a reach out of a third party stalking by way of Ms. Holmquist. Yes, I understand we have the other orders. Yes, we have had that taken care of. But to meet this would be an extension of what we have been dealing with. So we do believe that the preponderance of evidence, as far as the burden of proof from both the stalking, the First Amendment right was raised with regards to her Facebook posts. Yes, I understand that, and I will acknowledge, but I will offer to the court as part of that when you have a social media post, which is put purposefully in a very public manner, Facebook posts can be either private, you can have to be joined part of a group, or you can actually have to have them open in public. In fact, the 4 pages that information was shown on are public. They're out there open. While the children were not named, it was a post that was made immediately following the last hearing that we had with you. There was no it was intentional manner to be alarming. It was intentional manner to be derogatory, and to bring minor children into a situation on which they were, it was hard enough for them to testify. So I do believe that we're meeting the burden of proof with that as well. With regards to the distance, Mr. Pardee brought up, that she has other friends down here. While we're not asking for her to not be able to go to her friends, their house is currently on the upper north end side of the neighborhood. It's almost a mile away from our house. To make claims that she can even hear explosives and have some sort of knowledge that it would be down here, just further proves that there's no reason for any of us to be around each other, Your Honor. And Joe couldn't have been driving by. They're trying to dispel our burden of proof by saying that she counseled with her person so that she knew that she tried to do that. And in fact, the day that she made the call was early in the morning and Joe was at work. He could not have driven by her house 5 times that day. That's just an absolutely egregious thing. It just goes to show to our burden of proof of the tactics in which she would be willing to fabricate these. Once again, meeting the burden of proof for harassment, that it's an egregious nature, that it is an alarming, intentional, and otherwise. So based on those legal facts, Your Honor, I do believe we've met the burden of proof, and I do believe that this should be issued, and with the hopes that this is a moot issue at this point. But I believe that we've presented our case well, Your Honor.
Okay, I agree with a lot of what you've raised here. I do, and I agree also with Mr. Pardee that we're treading into some constitutionally protected areas as well. So, I want you to understand. I want all of you to understand that when I received this petition and I first examined it and I spent some considerable time with it, some of these issues were readily apparent to me as well. Now, I do want to start by saying that, Ms. Pardee's testimony in Ms. Holmquist's hearing 2 weeks ago, to a degree, her testimony is protected by a testimonial privilege. She's allowed to testify and say to the court anything that needs to be placed in the record in that hearing, and she's protected, generally speaking, from legal actions as a result of offering testimony. subsequent commentary that she posted regarding her reaction to the testimony of the children is in that area of constitutionally protected speech. Now, she obviously didn't think much of the kids' testimony, and she placed that opinion pretty clearly in her posting. But in her posting, she's not threatening the children. She's not threatening the Kabazinskis based on the children's testimony. She's not attempting to create the impression that somehow the children are at risk as a result of having testified in this hearing. There isn't any of that. It's just simply what you might call a nasty comment. So that's an example of where the First Amendment comes into the law as it relates to the unlawful harassment statute. Now, the unlawful harassment statute says that certain things are prohibited and can give rise to this cause of action, but it also says that constitutionally protected speech can't be prohibited with an anti-harassment order. And the First Amendment is an overlay to all of the legal analysis about that. So I can't just come to the conclusion that since Ms. Pardee is maybe a little bit of a busybody, or doesn't like the testimony she heard from the kids during the last hearing, that isn't going to subject her to an anti-harassment order. Now, getting to the real analysis, though, of the actions that she took and the statements that she made, and whether or not those meet the burden of proof to satisfy the elements of the harassment statute. I was concerned from the moment I read this that Ms. Pardee contacted Mr. Kabazinski's chain of command, effectively his employer. Now, it may not surprise you that I've heard many, many anti-harassment and stalking cases over the years, and that one of the tactics frequently employed by people who engage in that kind of behavior is to try to get their victims in trouble or fired or make life hard for them at their jobs by raising spurious accusations or, complete falsehoods, or trying to create in the mind of the employer that this employee is a bad one because you're always going to hear from third parties about them. And it frequently works. So when I read this, my thought went in that direction, that Mr. Kabazinski has an honorable employment with the United States military, and I'm sure that everything he told me about his career aspirations and his job responsibilities and the way he takes the integrity of his character seriously, I have no doubt about any of that, and he's sensitive to that being impugned in any way. Now, Mrs. Pardee offers an explanation for why she did what she did, and the assumptions that she made in making that call to contact Major Clemens. And I think that falls in the category of certainly mistaken. I don't think that it is reasonable to conclude. I didn't think this when I heard it in testimony in the hearing either. I don't think it's reasonable to conclude that because Mr. Kabazinski has a shed on his property that looks like a shed that was used by another person to manufacture explosives, that you can come to the conclusion that Mr. Kabazinski's manufacturing explosives. That's just an unwarranted conclusion. And to come to that conclusion and then take that another step further and report that to Mr. Kabazinski's employer can look an awful lot like an attempt to just make his life miserable because you're trying to victimize him. But it can also look like just somebody making a really bad and unwarranted mistake and making a phone call without fully realizing just how damaging a thing like that can be to somebody in Mr. Kabazinski's position as a United States soldier. So in this case, since the burden of proof is on the Kabazinskis, I'm not willing to conclude that Ms. Pardee did this maliciously or with a desire to simply harm and victimize Mr. Kabazinski. This is a one-off, and it's probably just an unwarranted and an unwarranted conclusion on her part. It doesn't require any further follow-up on her part. If there were to be any further attempts to contact Mr. Kabazinski's chain of command with similar types of allegations, that might look different in the future. So it might be in this party's best interest to come to the same conclusion I did, that it's somewhat ridiculous to conclude that Mr. Kabazinski's making bombs in his shed just because he's got a shed that looks like another one that you saw before where someone was making bombs. Now, the other aspect of this case that's been raised is, and I think is also important to understand, is that the Kabazinskis are very clearly very sensitive to the issue of defamation. In fact, I think they use defamation or slander or terms like that in describing Ms. Pardee's conduct and her words. And I'm not pronouncing any judgment here, of course, as to whether or not anything that Ms. Pardee did was defamation. Defamation is a cause of action that can't be heard in district court. It's also a cause of action that can't be heard in the context of an anti-harassment order. Whether or not Kabazinskis were defamed is beyond the scope of this hearing. So to the extent that your concern is that you're being defamed, your remedy for that is not in the district court. Your remedy would be elsewhere for that. And again, I'm not pronouncing any judgment as to whether or not actual defamation occurred. I know a lot of people raise that in anti-harassment petitions because they're concerned about it, and it may be a legitimate concern, but the court can't rule on it, is what I'm saying. So given that there's a burden of proof here that has to be met, and given the constitutional concerns that have been legitimately raised by Mr. Pardee here, and the fact that it looks like the incidents that are offered that constitute harassment are not really part of a willful course of conduct or pattern, but are more like, in my estimation, an isolated incident that occurred, I'm going to deny the petition. So with that in mind, I certainly hope that you can find a way to live together in this neighborhood without feeling the need to come to court so frequently. But if it's necessary, because the parties don't get the message and stop this, like I said, you're free to bring future petitions if conduct escalates. All right, so I'm signing the order now, dismissing or finding that the petition is not approved and denying it. There was no temporary order issued here, so there's no issue of an order expiring. All right, that will conclude the hearing for today. Thank you all of you.
Thank you, Ron.
Thank you, Your Honor, for your time. I appreciate it.
I appreciate your time too, Your Honor.
All right, your question.